Hello, Legal Honest welcomes you all to its YouTube channel. Today, we are going to talk about the issue of non-registration of FIR. We will be exploring what is the non-registration of FIR, what would be the remedies, and what would be the consequences if a police officer refuses to register your FIR. So, let's talk about this today. So, the issue of non-registration of FIR arises when a police officer does not register the FIR in the cognizable offence. Cognizable offence refer to those offences where the police officers are permitted to arrest the accused without a warrant. Section 154 clause 1 of CRPC provides that an FIR could be registered only in cases of cognizable offences. So, what section 154 clause 1 reads is every information relating to the commission of a cognizable offence, if given in orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. This section further provides that if an offence under Indian Penal Code has been alleged to have been committed against a woman and the said woman herself is the informant in the case, such information is to be recorded by a female police officer. So this was the section 154 clause 1 of CRPC. So we should talk about now refusal to register FIR. The police officer may legally deny registering the FIR in two circumstances. So first one is if a complaint is about an awfully trivial issue, and the second one is that if that particular police station does not have the territorial jurisdiction of that offence. So these were two circumstances. With regards to the first situation, it is very unusual for a cognizable offence to be a nugatory matter, so this condition would hardly apply here. The refusal to register FIR based on the second ground is pretty common in India, and the solution to which is the zero FIR. The concept of a zero FIR is that if a person is unable to file an FIR in the police station with correct territorial jurisdiction for a particular offence due to any reason, then he may file the same in any other police station within his or her reach, and such police station would later transfer the report to the police station which actually has the jurisdiction for that offence. If the police officer refuses to lodge the report on some unexplainable grounds or even without giving any reason, it would definitely be considered illegal. Then the aggrieved would have to seek remedy for the same as provided under the law. So these were the things about refusal of registrar. So now we should talk about statutory remedy against non-registration of FIR. Section 154 clause 3 of CRPC provides that if officer in charge of a police station refuses to register the FIR in a complaint of a person regarding a cognizable offence, then such aggrieved person can send the content of the information of crime in written form to the concerned superintendent of police SP via post so that the information could be recorded and investigated upon. After receiving the information, if the SP is contended with regards to the disclosure of a cognizable offence based on such information, then he would either examine the case by herself or himself or command any other subordinate police officer to do the same in accordance with the code. Also, the investigating officer would have the same powers as the officer in charge of the police station with respect to that investigation. So this was the statutory remedy. We should talk about now judicial remedy against the non-registration of FIR. If the remedy under section 154 clause 3 CRPC doesn't prove to be effective, then the informant can directly file a private complaint before the concerned judicial magistrate under section 156 clause 3 read with section 190 of the Criminal Procedure Code. This complaint should reflect the relevant facts. So first is that a cognizable offense has taken place. Second one is that the officer in charge of the police station has refused to register the FIR. And the third, that the remedy under section 154 clause 3 has not been so effective. So this was the judicial remedy. And what would be the consequences of non-registration of FIR? Let's talk about this now. The first is that the aggrieved person may file a writ petition in the respective High Court under Article 226 of the Constitution of India for the issuing of writ of mandamus against the delinquent police officers, and then the court would direct them to come up with the reasoning as to why they did not lodge the report in the very first instance. The second consequence would be the aggrieved person could go to file a writ petition in the respective High Court to seek compensation if such non-lodging of the report has caused the person deprivation of his right to life and personal liberty as guaranteed by Article 21 of our Constitution. The third consequence would be that Section 166A of the IPC lays down punishment for a public servant who fails to record information. Especially, subsection C of the section provides that failure on the part of a public servant to register any information under section 154 clause 1 of the CRPC with relation to certain offences against women would attract this section, and the said public servant shall be punished with rigorous imprisonment for a term which must not be less than 6 months but may extend to 2 years, and he shall also be liable to fine. So today we talked about the issue of non-registration of FIR, its remedies and the consequences. So this is enough for today. We thank you for watching this video, and if you like and you found it very useful, then please like, share and subscribe our channel. Thank you so much for watching this video.